Good afternoon, and welcome to the Quarles and Brady Business Law Training Session titled Anti-Counterfeiting and Brand Protection Strategies for China. I'm Kim Mahan, an attorney in the Business Law Group here in Chicago. Before we begin today's presentation, we would like to invite you to join us on November 8th for our next program on immigration. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the CLE sign-in sheets provided at the registration desk before you leave today. For our webinar guests, please fax or email the CLE form located at the back of the PDF materials to Sherry Cotis, whose contact information is on the form. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you after the program. Please be aware that this presentation is being recorded. And now I would like to introduce today's speakers. Lori Meddings helps clients protect and enforce their intellectual property throughout the world with a focus on maximizing the value of the company's trademarks and copyrights and defending against unfair competition in advertising. In all client interactions, Lori's primary goal is to understand the business and find solutions to legal challenges which meet the company's goals and objectives. Many of Lori's clients have a global presence and require advice and protection for their international IP portfolios. Lori has worked with numerous clients to combat counterfeit goods, especially in China, handling matters surrounding products that are produced and sold in China, as well as products sold worldwide. Li Zhu is a member of the firm's intellectual property practice group and specializes in developing strategies for registration, enforcement, and litigation of trademarks and copyrights with a focus in China. She started practicing intellectual property law in China in 2005, and her practice has been focused on anti-counterfeiting, brand protection, and IP portfolio management. Li started from a Chinese law firm, then worked as an in-house counsel for a multinational company, and later joined the Beijing office of a large international law firm representing the interests of a wide range of industries and clients. And now I will turn it over to Lori and Li.
Thank you. Thank you for joining us today for the program. So anti-counterfeiting has been an issue that I've frequently encountered in my practice over the years. And that's drawn me to China and an interest in China and finding new ways to effectively combat this issue that frustrates many. A little over a year ago, I met Li, and once we started working together, we realized how working together we could be a lot more effective. Li, with her background, helping clients on the ground in China solve problems, and my experience bringing in a more global perspective, helping clients at that level. Together, we've come up with a lot of creative solutions for clients, and we want to share some of those with you today. Today, we're going to talk about anti-counterfeiting and trademark squatting, and we'd like to also share with you some real case studies so that you can see how we actually employ these strategies and get results.
Thank you, Lori. Before starting today's presentation, I want everyone to be on the same page about what is trademark, counterfeiting, trademark infringement, and trademark squatting. As a majority of today's audience is from the US, we borrowed definitions of counterfeiting and trademark infringement from the US law. But the definitions in Chinese laws are basically very similar, except that only in China that only registered trademarks can be enforced against infringers. Even Chinese law carved out a tiny space for protection of unregistered trademarks. It's basically very difficult and the costs can be prohibitive. Trademark infringement sometimes can be very difficult to determine. Counterfeiting is a part of trademark infringement. Sometimes it can go both ways, or either way. It could be considered counterfeiting, or it can be considered trademark infringement. On the screen is a part of trademark applications filed by a Chinese squatter. It filed 283 applications targeting at several dozens of famous brands come from China and other countries. There are public records of these trademark squatters blackmailing brand owners for quote-unquote license fees. There was one American brand owner finally had enough and tried to stop paying the license fee. The squatter sued the brand owner on a Chinese court based on trademark infringement. And the squatter also requested China Customs to stop OEM products ordered by the American brand owner. There are three types of trademark squatters. For the purpose of this presentation, we bring to your attention the first type, counterfeiters. But we also want to mention during the escalation of trade war between China and the US, that the third kind, business partners, could be problematic. Before terminating any suppliers, we caution brand owners to take extra caution and audit if the suppliers is holding any rights belonging to brand owners. We hope you enjoy the presentation. I will hand it over to Lori. She will talk about anti-counterfeiting.
So when most people think of counterfeiting, they do think of China. So of course, we are going to focus on that today. We're going to start by talking about some background and then getting into some strategies and some of the enforcement tools that are available to us. So first, let's talk about some of the high-profile counterfeiting reports that we've heard about over the last few decades. Back in 1989, going back quite a ways, there was a horrible plane crash in Denmark. All 50 passengers and 5 crew members died. And once they did the investigation to determine the cause of the crash, they determined that it was due to counterfeits and inferior parts. In 2006 and early 2007, a cold medicine company a cold medicine product containing counterfeit ingredients caused a number of people to die in Panama, 120 people to be specific. And then shortly thereafter, in 2008, Heparin, another drug, resulted in 19 deaths in the United States. Counterfeits also impact Chinese consumers. In 2008, there was a horrific scandal involving counterfeit baby formula, and 64,000 children were violently ill, and some of them died. And there were legal actions taken against the counterfeiters in China, and then 10 years later, they did it again. So why take counterfeiting action? Why do we care about this issue? Well, in addition to the horrible cases that I just discussed, for day-to-day business, clients, individuals who are listening to this presentation today, you know that counterfeit affects business. It affects the bottom line. It affects the reputation of your brand, and it really does shake confidence. It can lead to increased incidents of product liability disputes and commercial litigation. It can also lead to consumers losing faith in your product and turning to others. So it's really become something that I think businesses feel that they have to tackle, at least to some degree. there's also many businesses that feel it's really a part of just corporate social responsibility, and that particularly comes into play when you are talking about things like baby formula and pharmaceuticals. So let's just look at some of the evidence that's out there. In 2015, China and Hong Kong together accounted for 86% of global counterfeiting and nearly $400 billion worth of goods. This really is all coming from China. Hong Kong's really a distribution hub. It's not where the goods are being manufactured. The other thing to point out is that machinery, equipment, automotive and parts, also tobacco, also cosmetics and personal care products, these are all things that are in the top categories of seized goods. These are reports from China Customs in 2017. There's also been a dramatic increase in the percentage of machinery and parts seizures. That's increased by 348% since the last report, which was in 2015. U.S. Customs has some similar but different reports, which we'll get into in the next slide or two. So, is your business a victim? And what's your plan? The first thing we do when we look at what's happening is we do an audit. We take a look at what trademarks does the business have currently protecting its rights in China. How is the coverage? Have you registered all of your marks? What marks have you registered? We do a cursory survey of social media, online retail platforms. We do an internal survey of business partners, dealers, salespeople. Let's see what kind of evidence you are uncovering already. And if you aren't already set up to capture this type of evidence, we can create some tools to do so. We also do other consideration of key markets so that we can determine outside of China, where else is the client's business focused? Where are they growing? Where are they seeing counterfeit goods? Or where are counterfeit goods at risk? So once we've done the study, we then will develop a budget and a plan. And the budget can be big or small. And just because you don't have a huge budget doesn't mean you can't start to tackle this issue. So our first case study is really, it's in the counterfeiting section, but it's really more of a trade dress infringement situation. In this case, the client had a machine with colors applied to the machine, protectable as a trademark, but back when we discovered it, the situation arose. The recognition of trade color marks, non-traditional marks, trade dress, all those words can be used somewhat interchangeably, was not well recognized in China. There were a couple other situations where others had registered those rights, but for the most part, it was a little bit of a novel approach. So we filed an application, but we couldn't wait for that application to get through because it was going to take a while. So we looked at where were the machines going. Well, the machines were being discovered in South America, Argentina in particular. So we talked to folks in Argentina, attorneys that we work with there, and determined that we would be able to easily register the color combination trademark there. We got that registration in place, we filed a lawsuit, and we had success. The lawsuit took us about 3 years to prosecute its way through the system, but we were successful. Meanwhile, things are still moving along in China. The registration issues, and once it issued and we had that in hand, it also kind of came around the same time that the law was continuing to develop as well. And as a side note, the law does develop and change very quickly in China. It's much younger than it is here, but it moves more quickly in terms of its development because they have just so much volume. So the registration's issued, and we were able to then immediately jump to action, sending cease and desist letters to the manufacturers of these machines, filing online takedowns through retail platforms, and we had a great deal of success within a very short period of time. And in China, spending a very relatively insignificant amount of money. Another case study involves a situation where the client had a customer complaint that came out of Taiwan. The customer had identified a product that it was complaining about, and the client said, well, this isn't even our product. This is a counterfeit good. This isn't even the form that we sell this product in. And so we did some digging, found out that the counterfeiter had already achieved a registration in China and was squatting, and the client had no registration in China. And at that point, we decided taking any action in China wasn't going to get us anywhere. And so instead, what we did was we sort of reinforced around that. We determined where the client's key markets were. We also focused on other Chinese-speaking countries and bordering countries, and we bolstered rights there because the counterfeiter hadn't thought to register in those other jurisdictions. And the client wasn't really doing business in China, and so they weren't as concerned about what was actually happening on the ground in China anyway. So in some respects, it worked out. But so in China, we don't need to run to the courthouse. That isn't always the best approach. It's more expensive, not as expensive as it is here, but still expensive. And there's also many other strategies that can be used short of that. So what we can, there's another type of action that's unique to China, an administrative raid. I'm going to talk about that on the next slide. But before we get there, cease and desist letters, like I explained in the first trade dress case, can be extremely effective. That can actually be a great warning shot to shut down smaller infringers in particular, those that are less sophisticated, those that really don't want to mess with the situation. They're in this to make money. If they're going to be disrupted, if they're going to be taken off their target of making money, they may move on to the next brand to exploit. The other areas that we can focus on are customs, and of course civil litigation is a last resort. Takedown of online listings is also a very important tool. Online marketplaces are huge in China. China's an enormous country, and so everything's spread out, not the same retail brick and mortar system that we have here, particularly in outlying areas. So everybody's heard of Alibaba. There's more than Alibaba. There's also Taobao, a website called 1688. There are social media platforms that don't, well, they exist here, but they're not as popular here, WeChat and Weibo. And so it's important to be sophisticated about which platforms to pay attention to and to address. So this slide is really, I'm not going to walk through this in great detail, but this is a really great slide to articulate the difference between administrative actions and civil litigation. In a straightforward counterfeiting case, we're generally going to lead towards an administrative action as opposed to litigation. If the infringer, if the issues are more complex, particularly if it is something like color trade dress, a configuration trademark instead of a word or a logo, civil litigation might be better. The judges are more sophisticated. There's more opportunity to explain the issues. The other situation where civil litigation might be more useful is when dealing with a major competitor, because there's also a sense of sending a message. Administrative actions can have shortfalls too. They can be not as effective because the punishment decisions aren't public, so there isn't that deterrent effect. There's also inconsistent enforcement standards. Different agents may have different levels of sophistication. They may be more motivated. They may be being persuaded by other factors. There may be, different issues as to why they aren't as effective in their efforts. They may just not be as educated on the issues. And so the other thing is, from office to office, there's different AIC offices around the country, so some are going to be more sophisticated than others. So take a look at that slide if you'd like to kind of consider that in more detail, and the cost. Customs actions are very effective tools, but they need to be followed by training. So if we file with customs, so once you get a Chinese trademark registration, you can record that with Chinese customs. Your job really isn't finished there. If that's all you do, the likelihood of customs being an effective enforcement tool is low. Customs is busy. They've got, you can imagine how many millions of items are going through their borders day in and day out. And again, you're dealing with government employees who have a varying degrees of sophistication and background on these issues. So training can really go a long ways. Not only are you actually giving them tools to use to determine if goods are counterfeit or not, but you're also getting in front of them, making sure that they realize your mark is something they should be aware of. This is particularly important if you're dealing with something other than, you know, a luxury brand or a popular consumer brand that, you know, the officials may not be naturally familiar with. The other thing to just point out, and this goes back to the other slides about customs, is there is some discrepancy in the reports from U.S. Customs, China Customs, even EU, in what they report as being their highest incidence of counterfeit goods seizures. You can see that there really is not a across-the-board correlation. And so it does beg the question of it, you know, where are the goods going? Are there errors in reporting? Are the goods leaving China and then not going to the U.S. and the EU? Maybe they're going elsewhere. It's a lot to consider and something that might be worth looking into in more detail. So it's possible to craft a manageable and effective anti-counterfeiting program, whether you have a proactive situation or you're really reacting. You know, if we do an audit and you find that, wow, we've got major issues, we can craft a program. But if you're also doing a proactive approach because you do an audit and you're in pretty good shape, your budget's going to be lower, which is nice, but you still probably should take some actions to prevent things from happening. So part of this strategy is going to take into account the very popular action of trademark squatting, and that's something that Lee is going to focus on next.
Thank you, Lori. I hope everyone is still with us here. If you get a little bit confused, it's okay, because that trademark practice in China could be very confusing. But if you walk out of the presentation and get totally lost, congratulations, I think you finally got it. But sometimes I feel every day. So as we mentioned that trademark squatting goes hand in hand with counterfeiting. We are going to give you two cases that Lori and I worked on. And we are also going to talk about two issues that we think foreign brand owners, especially US brand owners, haven't paid enough attention to. The first is coverage of trademark applications in China. The second is Chinese character mark. Sorry. When we say that we have to be the first to file, we suggest the brand owners to treat new trademarks as trade secrets. It means that we have to conduct a trademark search in all the jurisdictions for the mark intended for at the same time. We need to emphasize with local counsel a mark is confidential. We need to educate marketing and business people not to use a mark until applications are filed. We have to file applications at the same time in all the jurisdictions. And we also do not want to disclose any candidate marks to suppliers, distributors, or any other business partners before applications are filed. At last, we have to take into consideration of China market and trademark squatters into consideration to see if they would come into play later. And we also need to tell brand owners in the US and other jurisdictions that brand owners have to and can cover a broad range of products and services in China. First of all, that trademark registration in China enjoys a very narrow scope of protection. Many people know that products and services are categorized into 45 classes. For example, Class 7 covers machinery, Class 8 covers tools, Class 9 covers electronics, But in China, each class is further divided into many subclasses. Take class 7 as an example. It's further divided into 54 subclasses. Now I want everyone to imagine a box. So one subclass is a box. When a trademark registered on products or services on one subclass is like putting a mark into the box, and it gets protection within the box, but it cannot get protection out of the box. In other words, it means that a trademark registered on products or services on one subclass cannot get automatically protected outside of that subclass, which is totally different from most jurisdictions in the world. Taking the US as an example, a trademark registered on lighting systems in class 11 may get protection against another mark applied for on controllers of lighting system in class 9. This is not available in China. Because of the nature of the narrow scope of protection for Chinese trademark registration, when we file in China, we have to take into consideration what are similar products, what are related products, parts, services. If we don't touch base of all the aspects, there will be problems with trademark squatting. And then we also need to emphasize that brand owners can file on a broad range of products and services and maintain them. Because unlike it here in the US, that in China, trademark owners don't need to submit evidence of use or intent to use for registration. China Trademark Office does not ask brand owners for evidence of use from time to time, and even a non-use cancellation is filed that so long the mark is used on similar products, the risk of a cancellation is low. To play safe, brand owners can also always refile. In this case, the brand owner is the American company producing hair clippers for both animals and humans. The brand owner registered its Chinese housemark in class 8. Let's take a look, but it did not know that there's another hair clipper product in class 7. Let's take a look of hair clippers in class 7 and 8. We can see that hair clippers in class 7 and 8 are basically the same thing based on our research of the industry, that they look the same, have the same functions, they target the same consumers and share the same distribution channels. Companies in this industry produce products both for humans and animals. But as we said, a trademark registration enjoys a very narrow scope in China. The brand owner lost trademark opposition against the class 7 application for the same Chinese mark filed by a squatter. Not only he lost the opposition, but also 3 rounds of appeal before the Trademark Appeal Board, before the IP Court of Beijing, before the Higher Court of Beijing. What's worse? Its trademark office made a huge mistake and issued a registration certificate while the opposition appeal was still pending. But before that, the squatter had already started producing and selling counterfeits, attending trade shows, flaunting counterfeits, and also telling the brand owner, oh, you cannot sell hair clippers for animals because I have the application. The squatter also sent out C&D letters to distributors of the brand owner and requested administrative authorities to take actions against the brand owner. It was a priority for us to protect distributors, business partners of the brand owner from harassment, and also that we need to fight back against the squatter. In a case like this with an extremely hostile squatter, we monitor the case very closely. We discovered the mistakenly issued trademark registration certificate within 48 hours after its issuance. So that allowed us to react quickly, and we requested the Chinese trademark office to issue a validation statement, and we received that statement within a week. By the time the squatter received the registration certificate, probably not had enough time to celebrate. We already received the validation statement and we sent a copy to him. With the validation statement, that we could successfully stop administrative authorities from taking action against distributors of the brand owner. The key to solve the dispute was the application filed in Class 7 by the squatter. And the only way to remove that application was through a retrial of the opposition, the unsuccessful opposition. We studied all angles of the opposition, and we focused on several aspects that we believed would appeal very attractive to the People's Supreme Court of China, the highest court in China, and that strategy worked. So the SPC, the Supreme Court of China, decided to retry the case, which was huge, because that it suggests that the SPC believed there were mistakes made in the application of law, findings of facts, or there were many issues that the SPC may have ever ruled before, and the retry is still pending. To put more pressure on the infringer, and also to build up confidence of distributors of the brand owner, we requested take down counterfeits in trade shows and negotiated with trade show organizers to turn down requests of the squatter to attend all kinds of important trade shows. Furthermore, to send a strong warning to the public, especially potential business partners of the squatter, we filed a civil litigation based on trademark infringement and unfair competition. Because the records of civil litigation can be accessed by the public, once the squatter approaches any third parties for business opportunities, third parties would know that the infringer has no association with the brand owner and is merely a counterfeiter. At the same time, we find out that because of the business operation of the squatter did not go well in China, it attempted to sell in India. Not only had we secured registrations in neighboring countries, we suggested customs recordation and seizure action. Let's just pause and think. Had a Chinese counsel suggest the brand owner to file an additional application in Class 7 for an extra $500, that the squatter's application in Class 7 would never go through, and all the enforcement actions would be very straightforward. Counterfeiting of Chinese character mark is unique in China. However, the impact goes beyond China. We have to know that Chinese character mark is used in many markets with great purchase potential, including Hong Kong, Macau, Taiwan, Singapore, and also it's very well accepted in other major Asian markets, including Japan and Korea. It means that Chinese character mark has great business value for any Western companies. Here are some examples of popular American brands and how they use Chinese character mark in conjunction to English mark and the logo mark. There are two marks here. Give it a try. See if you can figure out who they are. The first one is 可口可乐. Anyone? Coca-Cola. Great. And the second one is 赛百味. Anyone? The Subway. So we think that they did fantastic job to design the mark because that Chinese consumers can easily associate Chinese character mark with the English mark. And the meaning is very interesting because it tells a story about the product. it added great value to the brand and to the brand in China market. In the last case study, the brand owner is a producer of medicated lip balms. The brand owner used a distributor to sell in China, and the distributor adopted and used a Chinese character mark without the knowledge of the brand owner. And the Chinese character mark became so popular and very well recognized. Then a trademark squatter filed the mark and registered the Chinese character mark in Class 3 on lip balm. In case you don't know, Class 3 covers cosmetics. The trademark squatter enforced very aggressively against the brand owner and asked the brand owner to stop using the Chinese character mark in China. In many of the cases that it's possible to change a Chinese character mark because that we can use marketing and PR support that we can recreate this kind of association between a Chinese character mark and English house mark. But in this case, because of the Chinese character mark became so popular and the brand owner was negotiating a new dealership with a bigger dealer in China, and that Chinese character mark became the center of the negotiation. So the brand owner was stuck with the Chinese character mark, and it was so expensive to buy back the mark. As we mentioned that a Chinese trademark registration enjoys a very narrow scope of protection, which usually plays against our clients and us. But in this case, we took advantage of it because that the trademark squatter registered only in Class 3, but not in other classes. And we figured out, oh, but the brand owner produces medicated lip balms. So we find out that actually the client could sell in China with a registration in Class 5. We did all kinds of studies and research of not only trademark law, advertisement law, regulations of producing and selling cosmetics and medicated personal use products in China, and we confirmed that point. So we designed a strategy to file a trademark in Class 5 for the brand owner's Chinese character mark. There was a problem, is that China trademark office generally requires trademark applications use only standard description of products and services, but medicated lip balms were not among them. So we designed a strategy to persuade trademark office to accept and approve lip balms for medical purposes and lip ointment for pharmaceutical purposes. With the registration in Class 5, the new dealer set up stores online and offline. This is just one of many examples that Chinese character mark could potentially put business opportunities in jeopardy, that it can cost brand owners some great opportunities. We mentioned that we have to strategize and plan out enforcement actions against counterfeiters worldwide on a global level. The same applies to tackle trademark squatting. We've seen some of the US brand owners complaining and finding out that Chinese squatters fighting in the US or in other important markets. But we have to stop and investigate. Does the squatter have an operation in China? Has it already registered a trademark in China? What is the business plan after that, behind it? Is it possible to stop it in China Is it cheaper to stop it in China? If we can stop it in other jurisdictions, or is it more efficient? So we have to we have to plan out. We have to think about the overall strategy, but not only looking at, oh, a Chinese squatter filed in the US. That was a lot of information to take in, but I want everyone to walk out of this section with just to remember three things. The first is first to file. The second is broad coverage. The third is Chinese character mark. And Lori will take over from here.
Before we leave this slide, actually go back one, sorry. Before we leave this slide, I just want to add a couple things to what Lee was saying. First, with respect to filing, I think that there is a little bit of a tension between, there's a typical, well, okay, if I file in another class, that's going to cost more money. Or in China, it's an actual separate application, and so that adds to the cost. I hope that everyone can appreciate from the discussion today that these filings are an absolute drop in the bucket compared to other actions that would necessarily need to be taken, and the protection gained is significant. Many companies make the choice to file in all 45 classes, and whether they're really belong in just one class or 3 or 4, all 45 classes. I will also say that if that's done, in order to kind of maintain those rights, you do have to refile, and there's like an early annuity on that. So you have to renew or refile really every 3 years. Otherwise, they become vulnerable to non-use cancellation. But it's definitely a strategy, and one that's very proactive, very comprehensive, but it shouldn't be dismissed as being overly costly, because if that's compared on balance with other efforts, it's really a much less costly endeavor. The other thing with Chinese character marks, and I was going to take questions at the end, but one came in from online that is something I was going to address anyway, which the question is, are transliterations like that, I'm assuming meaning like the ones that were highlighted, the Subway and Coca-Cola ones, better than actually trying to translate the words? It's a really good question. There really is no transliteration or direct translation. Instead, the character, and that's really the Chinese language, and I'll let Lee supplement this response as well, but really you come up with a name that has a pleasant sound and meaning, that bears some resemblance to the mark. That, although I will say in that case, the case study that Lee highlighted regarding the Chinese character mark, the distributor had actually adopted a mark that didn't really sound like the client's mark, nor did it bear any resemblance in terms of meaning. It was a cute and pleasant meaning. It was something attractive. It was almost more akin to a marketing slogan than it was the actual brand involved. But nonetheless, that Chinese name became strongly associated with the brand, and that's why it was so important. The other thing regarding the broad coverage is it's really helpful to have a proactive Chinese counsel involved. So, Lee is excellent in this space. There's a lot of Chinese attorneys who also can be very thorough, thoughtful, consider what are the related goods. They know the subclasses backward and forward. In my experience, there are a lot that do not do that do not have that. They say, what do you want us to file? We're a robot and we're going to file for that. So be very careful in that regard, because those are two very critical things in terms of dealing with the Chinese squatters. Lee, anything else that you would add to the question or the issue of the translation or what mark is selected?
I would say that the best choice would be a good transliteration with good meaning, which can be associated with your products and or services. That was the best, because that when Chinese consumers see that Chinese character mark, they will smile and say, "Oh, I get it." It's like,
Yeah,
it rings a bell. Yeah, I would say that.
great. So when we're thinking about how to approach China, about how to approach anti-counterfeiting, we really need to consider that this is a long-range thing. This isn't just let's do our audit and clean things up and then we're done. Unfortunately, China is not going to go away as a player in the global marketplace. They are not going to stop being, manufacturers and entrepreneurs there are not going to stop being creative about how to exploit others' brands and property. And so it's going to be an ongoing process. I talk with clients a lot about budgeting every year and how do we manage the issue of China. And I will say that it's become, once you start getting used to that, it is becoming more of this is built into our budget, and there's support for it because we have been able to gain some positive results for clients that make it so it's not difficult for them to allocate money to that. I think going back in my practice, maybe 10 years ago or more, when China was more of an absolute headache, everybody had a very negative impression of doing business with or in China. It was a much more frustrating situation to be in, and there was a lot of hesitation in investing in it. Unfortunately, I think that circumstance has played against a lot of companies because they didn't invest, and now the problem has gotten a little bit larger. So, conducting this audit is a very easy way to just get a lay of the land. It should be something that's updated regularly. The other thing is just general global trademark hygiene is, have a trademark watch, have a domain name watch, have some routine monitoring of social media and online sales platforms. Know what's going on out there. I mean, I know businesses look at what their competitors are doing all the time. You should be going beyond that and looking at what the marketplace is doing, because a lot of these counterfeiters and squatters, they're not your competitors. They're relatively small in the big scheme of things, but bring them together and put them all in the same bucket, and there's a lot of snakes in there. So just trying to educate the business as we go along about why trademark rights in China are important, why addressing these issues is important, is another way that in-house and outside counsel can work together. There's a lot of joint messaging that we can help with that really gets that message across. The other thing that we'd like to encourage lastly is think about the industry that you're in or that your clients are in. What's the industry seeing in this space? Is it, are you in the luxury goods space? And is this something that everybody's dealing with? It's absolutely a concern. Are there trade groups where you can collect together with your competitors to fight this issue together? I know that there are several, the luxury goods industry, the sporting goods industry, the bearings industry, the automotive industry, they all have trade groups that focus on anti-counterfeiting efforts and work together. So don't hesitate to go down those roads and to consider those options. Your competitors can be your biggest allies. So with that, we definitely have some time for questions. We figured there would be some. We'd be happy to address any sort of one-off requests regarding, what would you do in this situation? And I'd like to open it up to that.
Can you take some questions long distance?
Of course.
All right, so Lori Lee, what are your recommendations about the benefits and detriments for domestic enforcement purposes in China of an extension of protection through the Madrid system into China versus the traditional route of obtaining for the same mark a domestic registration directly into China?
Sure, and let me just start by, not everybody maybe is familiar with the system. So every country has its own trademark office and filing system. We can file with that office directly. There's also a treaty, an international treaty that the U.S. is a member of and that China is a member of. It's called the Madrid Protocol. You can file what's called an international application and then designate every country you would like to claim protection in, that as long as that country is also a member of the protocol. And so when you file that application, you have to file a home application first. So if you're a U.S. company, that home application is going to be here in the United States. The United States has very particular filing requirements. You ultimately have to use the mark in connection with the goods identified in your application. And so, let's say I'm filing for, let's say I make lawn and garden tools, and I'm filing for all sorts, spades, hoes, loppers, clippers, all these different things. Let's say I get to the point where I'm going to file evidence of use in the United States, and now it turns out I wasn't able to get a producer for some of these products, so I only have spades and hoes, no clippers or loppers anymore. Well, I can't claim that in the U.S. application anymore, so I have to drop those goods. So now that has a domino effect for all of the other applications that have been filed through this international registration system. In a country like China, you can see how that would quickly become it would be a problem. Because now, instead of having coverage even in one class, you have coverage in just a small portion of that class. And therefore, for all the reasons we talked about today, you are vulnerable. Because now the other thing is you have your trade secret, your mark is out of the bag, it's on file. All the counterfeiters, especially if it's a relatively well-known or becomes a well-known U.S. brand or global brand, all the counterfeiters and squatters are going to be aware of that application and that mark, and they're going to see opportunity there, and they're going to swoop in, and the problems begin. So for that reason, a Madrid Protocol application oftentimes is not the best tool when you're talking about China. Lee, do you have anything to add to that?
Yes, I have another point to add to that, that even in the U.S., that you are a massive U.S. company and you produce everything. Let's just say you produce everything. And then you have a registration in the U.S. and you extend this registration through Madrid to China. The problem is that when you get extended to China, they will not give you a registration certificate. They're going to give you a certificate saying, oh, this mark has been extended for protection in China. And with that certificate, it does not look like a registration certificate. And then when you take that certificate to enforce against the infringers before local enforcement authorities, they will say, hey, but I have seen trademark registration certificates before. It does not look like this. So more often than not, they will turn down the request and refuse to enforce it. It's we can say that the protection of a Madrid international registration in China should have the same kind of protection as a national application in China. But in fact, in practice, that is not the case. So we also need to take into consideration of the practical problem in China.
Right, and what Lee just described, it's this formality thing that's it seems so absurd, right? That it's a registration, and it effectively is a registration, but it doesn't look like one. So sorry, can't do anything. That actually happens, so. Thanks for the question. Any other questions that we can address? Yes?
To what extent are U.S. companies and other foreign non-Chinese companies trying to enforce their rights put at a disadvantage, and has that been affected, or do you expect it to be affected at all by the recent trade tensions and in particular accusations of IP theft?
Yeah. So Lee and I have actually been pretty on top of this issue. We've written a couple articles the last few weeks because while it has yet to play out what will happen, we anticipate there will be some issues that will arise because of the strain placed on pricing and the cost of goods essentially increasing because of the tariffs. We anticipate that someone's going to get squeezed on one end or the other, and so there's going to be some ramifications. And we think that could then also lead to additional infringements occurring. So one scenario we described in one of the articles we wrote is that if there is either the pricing gets off or there's less demand for the product because we can't sell it anymore because the margins are different, the Chinese manufacturers sitting there ready to go, right? They may have tooling, they may have other know-how, other ways of continuing to manufacture the product. So it may lead what used to be a good partner in the arrangement to all of a sudden become a counterfeiter. What we're concerned that when enforcement efforts when we try to enforce rights, particularly in a situation under that fact scenario, that local authorities may not be as supportive because of protectionism issues, because of formalities, things of that sort that will be easily leaned upon as a reason, but the underlying reason is likely to be the political minefield. Anything to add, Lee?
I also want to add a little bit about, especially with the administrative authorities, they have a very wide range of discretion to take or not to take actions, what kind of actions to take, and when to take actions. Also with Chinese courts, and that with our entity from overseas, that they don't have a strict timeline to issue a decision. So that could be a problem, because that in trademark infringement cases, we want to act fast. We want a heavier punishment. And if in this kind of, political tension come into play, that there are so many factors come into play that we may need to reconstruct the whole strategy. And we also need probably reach out a little bit more for help from allies, like your local business partners, other companies in the same industry, that you may want to consider to take a joint action against infringers, instead of going along and ask administrative authority, hey, can we take down counterfeits? Because that they may say, hey, I'm busy because there's a UK company just came in a little bit earlier. I'm sorry, just one of the examples maybe.
Any other questions? Okay. Great. Well, thank you so much for coming today. We appreciate it. If there's any questions offline, feel free to reach out.
Thank you.
Thanks.